I'm just trying to refer you to paragraph 15. I think we need to look at it, and so that we know what we are doing. If you rule that it is a criminal trial, we will know what to do. But let us at least point it out. Maybe we are misconceived. May I refer you, sir, to paragraph 15, 18. Please, you've spoken now. You don't want the truth to come out. Let me refer. Please sit down. I'm on my feet.
That's it.
Yes, sir. I'm trying to refer you to what will guide the tribunal. It won't take me 2 minutes. And if I mislead the tribunal, then any sanction can be sent on me. But why shouldn't I be asked?
2 minutes.
Yes, 2 minutes. I will do so, sir.
2 minutes.
18. It says, paragraph 18.1 of the 5th schedule, 18.1, where the Code of Conduct Tribunal finds a public officer guilty of contravention of any of the provisions of the code, it shall impose on that officer any of the punishments specified in subparagraph 2 of this paragraph, and any other punishment that may be prescribed by the National Assembly. And it refers to the punishments to include vacation of office, disqualification, and seizure and forfeiture. Then the next one says, the sanctions mentioned in subparagraph 2 hereof shall be without prejudice to the penalties that may be imposed by any other law where the conduct is also a criminal offense. So he's saying that where it is a criminal offense, it is another court that will do it, and that's what 6 says. It says, nothing in this paragraph shall prejudice the prosecution of a public officer punished under this paragraph, or preclude such officer from being prosecuted or punished for an offense in a court of law. The meaning of this is that you are not a court to try criminal cases. The punishments you are limited to is vacation of office, seizure, and forfeiture.
You are misconceiving the provisions of that particular
rules are misconceived.
Matters before this tribunal is criminal in nature.
No, sir, it's not. I've said here that I've referred you to the Constitution. If you take me, overrule me, it will be on record. This is the first port of call.
The fact before the court at this time is for the accused to take his plea.
We are saying, sir, with profound respect.
We will listen to you after the accused person has taken his plea.
Not even an accused person, is a defendant.
The defendant, let him be the defendant, but whatever it is, he should take his plea first before any other application is moved. That is the order of the tribunal.
Rules, sir, in writing. Then we know when we are going to get it. I referred you to paragraph 18.1 to say that this is not a court of criminal jurisdiction. And therefore, the Administration of Criminal Justice Act does not apply. Please, keep quiet. Let us respect this court. Please. Thank you very much.
Under the provisions of the Administration of Criminal Justice Act does not apply.
It does not apply because it is not a criminal court known under section 6.6 and the effect of section 33.8 and 12. of the Constitution shows that the code, it talks of breaches, does not call it an offense, it calls it breaches of the code of conduct. The breaches of the code of conduct as set out does not contain penalties attached to the written law. The administration of criminal justice irrelevant. In any case, the Administration of Criminal Justice Act, Section 6, applies to only federal courts.
So she said the Administration of Criminal
Yes, applies to only federal courts, magistrate courts in the FCT. This tribunal is not a court under Section 6. Subsection 6, and it is not a magistrate court. It is for the discipline, it's like the disciplinary committee of the legal practitioners for politicians. When they think they have transgressed a code of conduct, they bring them here and you discipline them. But they are not criminal offenses. Yes.
May I respect what my lords not to accept the invitation and the interpretation of the defense counsel on this issue. My lord, I'm happy that the learned counsel referred the lordships to paragraph 18 of the Constitution. Paragraph 18(1). He read it and he was quiet when he was reading it.
The defense referred to paragraph 18.
18(1). And he was quiet when he was reading it.
Yes.
It's only in criminal matter that the term guilty is mentioned in any enactment. No civil court can declare anyone guilty. He also read the word punishment. No civil court can impose punishment on litigants. These are criminal terms. So even from research submission, you knew that is not correct. You knew. But the reference to other paragraph of that is to show that apart from the punishment of code of conduct, the accused person or the person who contravened the code can still not be prosecuted in normal court. And that the issue of deputy jeopardy will not arise. That's the essence of what the issue of deputy jeopardy will not arise. That is the essence of that provision. That's the law.
Yes.
My lord, your lordship has also ruled on Monday. They are raising the same issue over and over. They don't want this matter to go on. That is the essence of it. Your lordship we have addressed your lordship on applicability of addition of criminal justice law, and your lordship ruled here today that is applicable, and it's raising it again. So, my lord, paragraph 17 of the rules of this court says that this court must apply the addition of the provisions of Criminal Procedure Act and Criminal Procedure Code, depending on the venue, my lord. And because the law as at then was repealed as at May this year, So the new Administration of Criminal Justice Law replaced those enactments.
Yes, what you
My Lord, we also My Lord, yesterday also when he was raising this similar issue, we by section 493, those acts were repealed. So, and when he was addressing this issue yesterday, we also cited to your lordship section 2 of the act. I'm sorry, my lord, it's section 1, subsection 2 and 3. Section 2, subsection 1, my lord.
Yes.
My lord, and he said, without prejudice to section 86 of this act, the provision of this act, that is Administration of Criminal Justice Act, shall apply to criminal trial for offences established by an act of National Assembly or other offences punishable in the Federal Capital Territory, Abuja. So, my lord, that act on its own said any court administering criminal justice system in Abuja should apply it. It says so. And the only exception is the subsection 2. So, the provision of this act shall not apply only to court martial. It's only court martial that say no, we cannot apply it. My lord, your lordship ruling yesterday, the party cannot come and say she will revisit your ruling of yesterday. Seeking for the same relief in 3 courts yesterday. That is what they are still doing this morning. Your lordship should compel the defendant go to the box. Our law is above every person, whether king or queen. The law must rule. The rule of law is that the accused person must go to the dock, and that is the position of the law. I hope your lordship will do so.
Just 2 points. First of all, sir, yesterday we were here for the issue of non-appearance of the defendant, and that was what we dealt with. No application was taken, and there were issues that were thrown up in that regard. That's number 1. Number 2, verify the answer to all that you have said to the against Code of Conduct Bureau 3 FHCLR. Yes, sir. Diarrhea against the Code of Conduct Bureau. Yes, sir. 2004 3 FHCLR. Pardon? 2004. Yes, sir. At page 501. If you permit me, sir, just the short part, paragraph F. Says this makes it more pungent and assuring that the Code of Conduct Tribunal is never conceived as a court by the Constitution, and no legislation of the National Assembly can empower it to act as a court or dress it with judicial powers, which are only meant to be exercised by the courts created by Section 6 of the Constitution. This conclusion has solved most of the nagging problems yet to be answered in this case. Since the Code of Conduct Tribunal is not a court and has no power of criminal trial, it cannot issue any warrant for the arrest or imprisonment of a person under any guise. In fact, the power given to the tribunal under paragraph 18 of the 5th schedule of the Constitution does not extend to ordering the arrest or detention of any person who contravenes the Code of Conduct. law which confers that power on the tribunal will definitely be consistent with the provisions of the Constitution and declared null and void. The third point is that the mention of court-martial, in Section 2 draws attention to the fact that court-martials already have criminal jurisdiction. That's why they are exempted. So because they have criminal jurisdiction, they can be excluded. You don't need to be mentioned as a tribunal because for the issue, you do not have criminal jurisdiction. You punish like the LPDC for misconduct or breach of the code of conduct, not a crime committed. It's not a corruption trial. He knows where to take corruption trials to. He goes to the Federal High Court. He doesn't even have a fiat to appear here. But we'll take all those issues in due course. He is what they call an interloper.
Senior Counsel is raising a new point already addressed on reply on point of law.
We expect that you're going to raise them during your preliminary question. At this point, there's no sound raising all these arguments. But later on, when proper proceedings
What I was making is that the high court decision which is cited regarding this case, the high court decision which is raised, is on warrant of arrest. The issue here is not whether, and that case, it can be tested. My Lord, even the National Assembly, while sitting as a lawmaking body, if there's someone anyone do not come, they have the power under our law to issue warrant to arrest the person. It's there. Even my Lord, this is not democracy. We are not here for politics. We are here for this serious business. My Lord, the people that are disturbing my submission, please allow me to make my submission. I'm doing my job. It's not democracy. It's not they are not the one to decide it. It's law. So, my Lord, the point which I'm making, my Lord, is that or even under panel of inquiry, they have power to summon persons to appear before them. How much more a tribunal created by the Constitution and their laws permit persons to be summoned, to even be detained under their law? Is there. So, my Lord, I believe that all these submissions are to mislead the court. That decision, with due respect, cannot override the statute that created this tribunal. That high court decision cannot. That's right.
The non-SNL provides the foreign that the tribunal has no criminal jurisdiction, while the prosecution submitted that the tribunal is a court that can exercise criminal jurisdiction. It is in view of the tribunal, it is in view of that the tribunal, having considered all the arguments of counsel on both parties, it is the well-considered ruling on the tribunal that trial before the Bukola tribunal is criminal in nature. as portrayed in the case of Federal Republic of Nigeria versus Atiku Abubakar, where Justice Aboki, Justice of the Court of Appeal, ruled that a trial in the tribunal is criminal in nature. On the strength of the petition supra, I hold that proceedings before this tribunal is very criminal. Consequently, all arguments can only be taken when the plea of the defendant is taken. It is also our ruling that the defendant, in view of the ruling, must enter the door to take his plea, and subsequently all other applications bordering on issue of jurisdiction or any other application can be properly taken afterwards. That is the order of the tribunal.
Bukola, Saraki, whilst being the executive governor of Kwara State, on or about 16 September 2003, within the jurisdiction of this honorable tribunal, did make a false declaration in the asset declaration form for public officers on assumption of office as governor of Kwara State by making an advisory asset declaration in that you claim to have owned and acquired number 15A and 15B McDonald Ikoyi Lagos through your company Kalisle Property Limited in the year 2000 when the said properties was in actual fact sold by the implementation committee on federal government landed property in the year 2006 to your companies Teni Tea Limited and BT Oil Limited for the aggregate sum of 396,150,000, and you thereby committed an offense under Section 15 of the Court of Conduct Bureau and Tribunal Act, Cap C-15, Laws of the Federation of Nigeria 2004 as incorporated under paragraph 11, subsection 1 and 2 of part 1, fifth schedule to the Constitution of the Federal Republic of Nigeria 1999 as amended and punishable under section 23, subsection 2 of the Code of Conduct Bureau and Tribunal Act as incorporated under paragraph 18 of part 1, fifth schedule to the Constitution of the Federal Republic of Nigeria 1999 as amended. How do you plead? Guilty or not guilty?
Mr. Chairman, I want to say that I'm a true believer in the rule of law. I have come here with great respect to that. And I believe to look as a way of defending my rights. I've come here to subject myself. I believe that I'm here, strongly believe I'm here, because I am the Senate President. I don't believe I'd be here if otherwise. Mr. Chairman, I want to say that I observed that we made reference to some of the good work the Senate has done in the criminal administration. The same Senate was the one that passed the Code of Conduct Bureau Act 2001 that clearly states in Section 3D that I just want to make these opening remarks to show that I believe in the rule of law. Section 3D says there that if there is a breach of the asset declaration, the Code of Conduct Bureau shall refer the matter to the Code of Tribunal after giving the person an opportunity to either confirm whether those facts are true, and if at least the matter shall not be referred to the Tribunal. Well, I will now go ahead because I want to explain why, Chairman, I will now go ahead and accept. I just wanted to state that for you to understand as a layman why I find I'm puzzled why I should be before the tribunal. I thought that the Code of Conduct should have first called me according to the law, because we have been talking here about the new Nigeria. We have been talking about, especially the prosecutors, we're talking about Nigeria going forward. Mr. Chairman, this is the first time, and we are all watching, we are before the world, not before Nigeria. And we all should be seen to do. I will confine myself with the due process. And that is why I felt that before now, some of those issues need to be raised. So, as stated, I want to say that I'm not guilty.
Please, court in order, please. This is not one of the charge. Please, let us listen, please. Let us listen. We need decorum, please. We need decorum. Everything we are doing there is for the benefit of all of us. So, count two. That you, Dr. Bukola Abubakar Saraki, yes, sir. The first count charge now. Charge, the defendant said not guilty. Count two, that you, Dr. Bukola Abubakar Saraki, while being executive governor of Bukola State between October 2006 and May 2007, within the jurisdiction of this honorable tribunal, did acquire properties after your declaration of asset on the assumption of office in 2003, to wit number 70A and 70B, Madonna Ikoyi, Lagos, from the Implementation Committee on Federal Government Landed Properties in the aggregate sum of 497,200,000, which acquisition was not fairly attributable to your income, gift, or loans approved by the Code of Conduct for Public Officers, and which you wrongly claim to have acquired from proceeds of sale of rice and sugar commodities, and you thereby committed an offense under Section 15, subsection 1 and 2, subsection 3 of the Code of Conduct Bureau and Tribunal Act, Cap 615, Laws of the Federation of Nigeria 2004, and as incorporated under paragraph 11, subsection 1, 2, and 3 of part 1 fifth schedule to the Constitution of the Federal Republic of Nigeria 1999 as amended and punishable under Section 23, subsection 2 of the Code of Conduct Bureau and Tribunal Act, and as incorporated under paragraph 18 of that when fifth schedule to the Constitution of the Federal Republic of Nigeria 1999 as amended. How do you plead? Guilty or not guilty?
Just as I said in the earlier phase, not guilty.
My Lord, he said not guilty. Count 3. That you, Dr. Bukola Abubakar Saraki, on or about 3rd June 2011, within the jurisdiction of this Honorable Tribunal, did make false declaration in the asset declaration form for public officers at the end of your tenure of office as Governor of Kwara State in 2011 by refusal to declare Plot 2A, which you acquired between 2007 and 2008 through your company Calisplay Property Limited from the Central Bank of Nigeria for a total sum of 325 million, and you thereby committed an offense under Section 15, subsection 1, 2 of the Code of Conduct Bureau and Tribunal Act, Cap C-15, Laws of the Federation of Nigeria, 2004, and as incorporated under paragraph 11, subsection 1 and 2 of Part 1, fifth schedule to the Constitution of the Federal Republic of Nigeria, 1999, as amended and punishable under Section 23, subsection 2 of the Code of Conduct Bureau and Tribunal Act, and as it incorporated under paragraph 18 of Act 1, fifth schedule to the Constitution of the Federal Republic of Nigeria 1999 as amended. How do you plead?
Not guilty.
Or not guilty?
Not guilty.
My Lord, you pleaded not guilty. Count 4. That you, Dr. Bukola Abubakar Saraki, on or about 3rd June 2011, within the jurisdiction of this Honorable Tribunal, did make a false declaration in the asset declaration form for public officers at the end of your tenure of office as Governor of Kwara State in 2011 by your refusal to declare Plot 37A Global Road, Ikoyi, Lagos, which you acquired between 2007 and 2008 through your company, Castly Property Limited, from the Implementation Committee of the Federal Government Landed Property for a total sum of 325 million, and you thereby committed an offense under Section 1 and 2 of the Code of Conduct Bureau and Tribunal Act and 50, Laws of the Federation of Nigeria 2004 as incorporated under paragraph 11, subsection 1 and 2 of Part 1 fifth schedule to the Constitution of the Federal Republic of Nigeria 1999 as amended and punishable under Section 223, subsection 1 of the Code of Conduct Bureau and Tribunal Act, and as incorporated under paragraph 18 of Part 1 fifth schedule to the Constitution of the Federal Republic of Nigeria 1999 as amended. How do you plead?
Not guilty.
He pleaded not guilty. Count 5. That you, Dr. Bukola Abubakar Saraki, while being in the office as Executive of Kwara State, or about 16 September 2003, within the jurisdiction of this Honorable Tribunal, did make a false declaration in the asset declaration form for public officers on the assumption of office as Governor of Kwara State in 2003 by a refusal to declare number 1 Tabu Street, Maitama, Abuja, otherwise known as Plot 2482, Cadastral Zone A06, Abuja, which you claim in your end of tenure asset declaration form in 2003 to have acquired in November 1996 from one David Baba Akawu, and you thereby committed an offense under Section 15, Section 1 and 2 of the Code of Conduct Bureau and Tribunal Act, Cap C-15, Laws of the Federation of Nigeria, 2004, 2004, incorporated under paragraphs 11, subsection 1 and 2 of Part 1, future rule to the Constitution of the Federal Republic of Nigeria 1999, as amended and punishable under Section 23, subsection 2 of the Code of Conduct Bureau and Tribunal Act, as incorporated under paragraph 18 of Part 1, future rule to the Constitution of the Federal Republic of Nigeria 1999, as amended. How do you plead? Guilty or not guilty?
Not guilty.
You pleaded not guilty, my lord. Count 6, that you, Dr. Bukola Abubakar Saraki, on or about 16 September 2003, within the jurisdiction of this honorable tribunal, did make a false declaration in the asset declaration form for public officers upon assumption of office in the year 2003 as governor of Kwara State by your refusal to declare number 3 Tabu Street, Maitama, Abuja, otherwise known as plus 2481 Cadastral Zone 806 Abuja, which you acquired through your company, Kalisri Property Limited, from one Alhaji Atahiru Adamu before your assumption of office, and you thereby committed an offense under Section 15, subsection 1 and 2 of the Code of Conduct Bureau and Tribunal Act, Cap C-15, Laws of the Federation of Nigeria, 2004, and as incorporated under paragraph 11, subsection 1 and 2 of Part 1, feature 2 of the Constitution of the Federal Republic of Nigeria 1999, as amended and punishable under Section 23, subsection 1 of the Code of Conduct Bureau and Tribunal Act, and as incorporated under paragraph 18, Part 1, future due to the Constitution of the Federal Republic of Nigeria 1999, as amended. How will you plead?
Not guilty.
Not guilty, my lord. Count 7, that you, Dr. Bukola Abubakar Saraki, on or about 11 July 2007, within the jurisdiction of this honorable tribunal, did make a false declaration in the asset declaration form for public officers upon assumption of office for the second time in the year 2007 as governor of Kwara State by your refusal to declare number 3 Tabu Street, Maitama, Abuja, otherwise known as plot 2481, Cadastral Zone 806, Abuja, which you acquired through your company, Castle Property Limited, from when Alhaji Atahiru Adamu before your assumption of office, and you are thereby committed an offense under Section 15, Section 1 and 2 of the Code of Conduct Bureau and Tribunal Act, Cap C-15, Laws of the Federation of Nigeria, 2004, as incorporated under paragraph 11, Section 1 and 2 of Part 1, Feature 2, to the Constitution of the Federal Republic of Nigeria 1999, as amended and punishable under Section 23, subsection 2 of the Code of Conduct Bureau and Tribunal Act, as incorporated under paragraph 18, Part 1, Feature 2, to the Constitution of the Federal Republic of Nigeria 1999, as amended. How do you plead?
Not guilty.
Not guilty, my lord. Count 8, that you, Dr. Bukola Abubakar Saraki, on or about 4th June 2011, within the jurisdiction of this honorable tribunal, did make a false declaration in the asset declaration form for public officers at the end of your tenure of office as governor of Kwara State in 2011 by your refusal to declare number 3 Tabu Street, Maitama, Abuja, otherwise known as plot 2481, Cadastral Zone, Abuja, which you acquire through your company, Castle Property Limited, from when Alhaji Atahiru Adamu before your assumption of office, and you are thereby committed an offense under Section 15, subsection 1 and 2 of the Code of Conduct Bureau and Tribunal Act, C-15, Laws of the Federation of Nigeria 2004, and as incorporated under paragraph 11, subsection 1 and 2 of Part 1, Feature 2 to the Constitution of the Federal Republic of Nigeria 1999, as amended, and punishable under Section 23, subsection 2 of the Code of Conduct Tribunal Bureau and Tribunal Act, and as incorporated under paragraph 18 of phase Part 1, Feature 2 to the Constitution of the Federal Republic of Nigeria 1999, as amended. How do you plead?
Not guilty.
Pleaded not guilty. Count 8. Count 9. Count 9. That you, Dr. Bukola Abubakar Saraki, while being in the executive government Governor of Kwara State on or about 16 September 2003 within the jurisdiction of the Honorable Tribunal did make a false declaration in the asset declaration form for public officers on assumption of office when you falsely claim to own an asset to wit number 42 Garal Road, Ikoyi, Lagos, in which you claim to earn 110 million per annum through a company known as Skyview Property Limited, when the said property was under construction, and you thereby committed an offense under Section 15 of the Court of Conduct Bureau and Tribunal Act of C-18 Laws of the Federation of Nigeria 2004 as incorporated under paragraph 11 subsection 1 and 2 of Part 1 fifth schedule to the Constitution of the Federal Republic of Nigeria 1999 as amended and punishable under Section 23, subsection 2 of the Court of Conduct Bureau and Tribunal Act, and as incorporated under paragraph 18 of Part 1, fifth schedule to the Constitution of the Federal Republic of Nigeria 1999 as amended. How do you plead?
Not guilty.
Not guilty, my Lord. Count 10. That you, Dr. Bukola Saraki, on or about 3rd June 2011 within the jurisdiction of this Honorable Tribunal did make a false declaration in the asset declaration for the public officers which is submitted at the end of your second tenure as Governor of Kwara State. Within it, you failed to declare the loan in the sum of 375 million naira obtained from Guaranteed Trust Bank in February 2003. The proceed, which you converted into Great Pounds Sterling in the sum of 1,516,994.53 cents of and remitted to Fortis Bank SA/NBA as full and final payment of mortgage redemption for the undisclosed property you purchased in London, and you thereby committed an offense contrary to Section 15 of the Court of Conduct Tribunal and Tribunal Act of C-15 Laws of the Federation of Nigeria 2004 and punishable under Section 23 subsection 4 thereof as incorporated under paragraph 18 part 1 schedule to the Constitution of the Federal Republic of Nigeria 1999 as amended. How do you plead?
Not guilty.
Pleaded not guilty. Count 11. That you, Dr. Bukola Saraki, on or about 27 August 2008, within the jurisdiction of this Honorable Tribunal, while being a public officer as the Executive Governor of Kwara State, did operate a bank account outside Nigeria. While 38 cents from your Guaranteed Trust Bank for PLC, domicile account number 441-953210 to the American Express Service Europe Limited, number 730580 for onward credit to your American Express Bank, New York, card account number 37488216836009, and you thereby committed an offense contrary to paragraph 3 of Part 1, fifth schedule to the Constitution of the Federal Republic of Nigeria as amended, and Section 7 of the Court of Conduct Bureau and Tribunal Act, and punishable under paragraph 9 of the said fifth schedule to the Constitution of the Federal Republic of Nigeria 1999 as amended, and Section 23 subsection 2 of the Court of Conduct Bureau and Tribunal Act. How do you plead?
Not guilty.
Count 12. That you, Dr. Bukola Saraki, between August 2009 and October 2012, between the jurisdiction of this Honorable Tribunal, while being a public officer as the Executive Governor of Kwara State and Senator of the Federal Republic of Nigeria, did operate a bank account outside Nigeria. Within you transferred the aggregate sum of $400,000 from your Guaranty Trust Bank PLC, domicile account number 441-441-953210 to the American Express Service Europe Limited, number 730580 for onward credit to your American Express Bank, New York. Card account number 374588216836009. And you thereby committed an offense contrary to paragraph 3 of part 1, schedule to the Constitution of the Federal Republic of Nigeria as amended, and section 7 of the Code of Conduct Bureau and Tribunal Act as punishable under paragraph 9 of the said fifth schedule to the Constitution of the Federal Republic of Nigeria 1999 as amended, and section 23 subsection 2 of the Code of Conduct Bureau and Tribunal Act. How do you plead?
Not guilty.
The last count charge, count 13. That you, Dr. Bukola Saraki, on or about 16 September 2003, within the jurisdiction of this honorable tribunal, did make a false declaration in asset declaration form for public officers upon assumption of office in the year 2003 as governor of Kwara State by your refusal to declare your leasehold interest in number 42 Remi Fani Kayode Street, Ikeja, Lagos, which you acquired through your company, Skyview Properties Limited, from Trust Finance Trust Limited on 12 December 1996, and you thereby committed an offense under Section 15, subsection 1 and 2 of the Code of Conduct Bureau and Tribunal Act. Cap C-15, Laws of the Federation of Nigeria, 2004, and has incorporated under paragraph 11, subsection 1 and 2 of part 1, fifth schedule to the Constitution of the Federal Republic of Nigeria, 1999, as amended and punishable under section 23, subsection 1 of the Constitution of Code of Conduct Tribunal and Bureau and Tribunal Act, and as incorporated under paragraph 18 of part 1, fifth schedule of the Constitution of the Federal Republic of Nigeria, 1999, as amended. How do you plead?
Mr. Chairman, just as I said in the opening, just as I said in my opening comment, as against Section 3, the Code of Conduct Bureau, this is the first time this is being brought to me. The law says that before now it should be brought to me, and before me it should not be brought for a tribunal. I just want to put down records. I plead again, not guilty. We have institutions, your institution, judiciary, and the Senate that are attest today. And I pray that in the interest of this great country, we both do the right thing that is necessary to put this country forward. And I plead docket, I thank you.
My Lord, he pleaded not guilty. Thank you.
Next question.
The issue of law that he was raising while taking his plea, because those laws, according to himself, are based on wrong advice, because and they are contrary to the ruling of this court. He has raised this point that is raising now in the dock. This court has ruled that under Section 3, that is relying on that it cannot override the constitutional provision. So he has sworn to uphold the Constitution. So it cannot be hard to be arguing point of law from the dock. It's for his counsel. So my Lord, I want your Lordship to discountenance whatever it says there. My Lord, that is the first point I made. My Lord, after the plea of not guilty is recorded, my Lord, I refer your Lordships to the third schedule, your order, your rules, that third schedule, paragraph 5.
Yes.
My Lord, just schedule paragraph 5. And it says, my Lord, that after the plea of not guilty has been taken or no plea has been made, the prosecutor may open the case against the accused, stating shortly of what evidence he intends to prove the guilt of the accused. So my Lord, that is my Lord, I'm also referring your Lordship on section 300. I have clearer copy. Is it clear? I also refer your Lordship to section 300, subsection 1 of the Administration of Criminal Justice Law. And it has the same effect, that after the plea of not guilty has been taken or no plea has been made, the prosecutor may open the case against the defendant, stating shortly by what evidence he intends to prove the guilt of the defendant. So, my Lord, that is what is I'm expected to do, and also under your Lordship's the rules of this court, apart from Administration of Criminal Justice Law. Yes. I intend to discharge my duty by stating briefly the evidence I want to call. Yes. My Lord, it's not beside me. He said he cannot stop me, so he said your Lordship stop me. So yes, I will do that.
Yes, yes.
This Honorable Tribunal ruled just a few minutes ago that the business of the day was for plea to be taken. Plea has been taken. He has pleaded not guilty. At this point in time, going by the ruling of the tribunal that other applications challenging jurisdiction can now be taken, unless, and I know that I'm before a very honorable tribunal, that the tribunal will keep to its word, that we are entitled to raise those points that are already filed. I don't know, but we have the Constitution. Yes, I'll do it. Well, since your Lordship of this, Your Honor has ruled, and that represents the law until otherwise set aside, that the proceedings are in the nature of a criminal proceedings. We are then bound to draw your attention to section 36(6)(b) of the 1999 Constitution.
Yes.
Especially having regard to the preamble made by the defendant in the dock, that he is just coming across these facts for the first time as it was read today. Section 36(6)(b) says, every person who is charged with a criminal offense shall be entitled to be given adequate time and facilities for the preparation of his defense.
That's considered punishment.
Yes, and it's the paramount provision that governs all of us. We cannot wave it aside. And so because of its primacy, it is important that adequate time, especially even speaking as a layman, he told the tribunal that he was just coming across these charges for the first time. Jacob will tarry a while. let the Constitution, let him be given adequate time and facilities to brief and instruct his legal team and that's while making this application. So I said, you need adequate time and facilities to instruct him. Again, I brought him to the tribunal this morning.
Yes.
The warrant did not need, it was not necessary to, I in fact called my landlord's cell at about 5 p.m.
This morning.
No, yesterday, and told him that it would not be necessary for the warrant to be executed. So he's here on his own volition. And having said that the proceedings are in the nature of a criminal matter, but I've checked with the practice of this tribunal. You do not presume that he's guilty until he's proven so, and therefore consistent with the presumption of innocence, and also consistent with the sensitive office he occupies, and the fact that I admit that it was based on my advice to test the law, the higher courts, that he had not been here. He has told you that he's a law-abiding citizen. So based on those grounds, on the provisions of section 163, 164, and 165, and 36 of the Constitution, I'm applying that you release him back to me on bail, on his own self-recognizance, as he will always be the tribunal throughout the proceedings. That's my application. And also for an adjournment, so that we can receive full instructions and then come and argue the application in respect of jurisdiction.
Okay, first thing, the fact you have stated earlier that the defendant actually comes here on his own volition. So we want to say that the earlier order bench warrant which was which is hereby vacated. The bench warrant is of no consequence for some. Yes. Prosecution.
Yesterday, it will be in court, and following the tradition at the bar, the defendant was not arrested, and Leonard Counsel shows that the president, he was the former president of NBA, and brought him this morning. On a lighter mood, I must appreciate him. That is a tradition that we met at the bar, and I pray that that kind of tradition will continue. However, the point I made, the Leonard Counsel didn't come out well. I guess his adjournment he wanted, because he's saying that adequate time and facility. My Lord, the point I raised is not the role to be played by the defendant in any form. What I said, my Lord, I want to state the fact in accordance with what the law says. So, and that would not in any way affect his presumption of innocence or issue of fair hearing or adequate time. It's when I state my fact, then he can proceed with his motion. So then, if he has any motion to pursue, because I believe that all those issues that he filed motion for have been raised orally, and the court has ruled on them. So, and they have even filed an appeal on it. The same point they took to Federal High Court. The same point at the Court of Appeal. The same point here. So, my Lord, I want to say, my Lord, that the fact that I state the fact will not take away his right to adequate time and facility to prepare his defense. We have served him more than 7 days. It is not true that he's hearing it for the first time today.
Yes.
So, my Lord, it is not true that he just first time here. That cannot be true. That cannot be true. He has tried papers since last week on this charge. So, my lord, the right to adequate time and facilities, he has been given all the facilities. Even the fact I want to say, are the facility that we gave to him. The proof of evidence, everything. The witnesses want to call. So adequate time and facilities that are guaranteed by the Constitution and supported by the rules of court and addition of criminal justice law.
Yes.
So
By the intendiment of the Criminal Administration of Criminal Justice Act is to basically to effectively and efficiently dispense with criminal matters.
Within time, my lord.
Within time.
Yes, my lord.
The position will be given opportunity to present.
And it's to be, and particularly section 396, it's supposed to be day-to-day trial, where it is section 396, section 4, supposed to be day-to-day. So the issue of the adequate time and facilities cannot arise. We are here now. He has gotten all the facts, he has gotten all the documents, he has been served with the proof. So, my lord, so that's my humble reply to what the learned counsel says. My lord, the issue of base is taken for granted because I will not stand here to oppose any bail for. We are gentlemen, it's not even bail issue here.
The fact is that the defendant having brought himself back voluntarily, we are going to say he's not going to go back anyway. He is going back.
Yes, my lord.
I'm not going to call him, I'm not going to ask for any documents, I'm not going to ask for any documents. He's on his own, he can go back and come back at the next time. Again, he must for him to present his facts. Do you have anything to say? I'm also saying, we are all ministers in the Temple of Justice, and we want to do justice not only to you, but also to the prosecution, and whatever we do, we're doing it for posterity. So we must do what is right.
And the first of all, good to us, because we are also entitled to justice.
Yes,
The point is that the Administration of Criminal Justice Act does not override the Constitution. It is the other way around. The Constitution says, give us adequate time and facilities to prepare for defense.
yes.
Then we can come on this basis. I have not received any instruction. It will be highly prejudicial for him to go on with this. When I have cited the provision of the Constitution, it's in fact, I don't know what he will be talking about.
Okay, I'll ask now. It's okay.
So the point remains that we need time and facilities. We thank you for the direction on his liberty. All we are saying is that this is the time to go home. Let me take his briefing, and then we'll be here fully. Let's go for Salah and come back. My Lord, back at the Salah.
I think we have addressed these things sufficiently. I do not think that he has the right to dwell on that in his last address, because the Constitution did not define what constitutes reasonable time, adequate time. The times as prescribed by law, addition of criminal justice law. They are the statutes that define what amounted to adequate time.
Yes.
So, my lord, it does not derogate from the Constitution itself. So, whereas they came into it. Constitution is a general principle of law that's provided that you must give adequate time. What constitutes adequate time? It's in accordance with the law. The law says these are the things we should do immediately after the plea issue. The prosecutor should state his case. Immediately after that, he can then ask for adjournment. But for learned counsel to say that he has not taken instruction after he has filed papers, after I filed papers, my lord, he cannot say that he has not taken it. He cannot even be heard from the senior counsel. A counsel filed papers since last Friday to say that he has not received instruction. My lord, he cannot do that.
Prosecution
Cannot.
will give me the opportunity to shortly state the evidence you intend to prove of the guilt of the accused person. Just very briefly.
As the God pleases, my lord. My lord, the point which I'm obliged to do is that I'm trying to prove, my lord, is that the defendant or the accused, as your rule says, he made 4 asset declaration forms.
4 asset declaration.
The 4 asset declaration form.
Yes.
My lord, and it was those 4 asset declarations form that were investigated. He made one in 2003, 2 in 2007.
Let me take it.
Yes, my lord.
He made a 4 asset declaration for 1, which was investigated.
Yes, my lord.
And 1 was taken in 2011.
In 2003,
2003, yes.
Yes, my lord. Another one was made on 11th July 2007. 2007.
2007.
Yes, my lord.
Yes.
It made the same asset declaration form, the 3rd one, in 2007.
In another 2007.
Yes, my lord. That is, there are 2 asset declaration forms that he made
in 2007. Yes.
My lord, the final asset declaration he made was in 2011 too. My lord, before this charge was filed, these are the only asset declaration form with the Code of Conduct Bureau.
Yes.
It's at the time when this charge was filed. These are the only 4 asset declaration form. My lord, in those asset declaration form, my lord, the prosecution will lead evidence. My lord, the asset declaration form are also in the proof of evidence. We annex them to the proof of evidence. All the asset declaration forms that you fill. My lord, all the properties. My lord, your lordship will observe from the asset declaration form he made in 2003. The defendant claimed that he acquired number 15A and 15B, McDonald Ikoyi. In 2003, my lord.
Rotimi, I don't think that's what the law requires you to do. Give us a summary of what is involved.
No, that's what I'm trying to do.
No.
Maybe I'm going too deep.
You are going too deep. We don't need that now.
As the accomplices. My lord, we will call only 5 witnesses to prove our case. And we will show to your lordships that the defendant made an anticipatory asset declaration. It said he acquired property in 1996, and he filled it in 2003 in his asset declaration form. Whereas your lordship will see the title document of the same asset from the proof of evidence, where the presidential committee, headed by the then minister El-Rufai, sold the same property to him in 2007. It's not a political statement. My lord, that is to show the morality of this very sad sad. Very sad indeed. Very sad. So, my lord, apart from that, we will also lead evidence as to property he acquired while he was governor between 2003 to 2011. All the assets he acquired, and because he acquired those assets while he was governor, he never declared those assets. So, and we discover and we got the title documents. They are also in the form of evidence.
Yes.
The account he opened, how he moved money out of Nigeria to UK, to United Kingdom, and to London. We will also leave evidence to that. My lord, we just need 2-3 days to open our case,
yes,
and to conclude and close our case.
Yes.
So, my lord, I'll be urging my lord to give us 2 clear days prior. Yes, my lord.
All right. Last question, Lotini.
Yes, my lord.
Are you done?
Yes, my lord.
Yes. Having said that, and having read the plea to the accused person, he has not pleaded guilty, and then having joined issues by the both parties, so we will take a date now.
Yes, please.
So that you will come and produce and submit a state your evidence, and then of course opportunity will be given the defense to examine all the witnesses, and then we'll proceed.
As a complices.
So all we need now is to have a clear day in which we can come and deal with this issue.
As a complices, my lord.
Yes.
We are grateful, my lord. I was thinking that they will be ready. I have my witnesses here. I was thinking that they will be ready. My witnesses. They are here. They are here. for me, it's not that it's far from me, it's far. But since I don't want to have, I don't want to be like Olipatu. So I will proceed.
It's not very far. It's not far.
Yes, I think I'm going to take that Yellow proceeding to the gate. And this people getting ready to take his pictures there. So I don't know if you can discharge it from the box. Don't take anything out.
The 21st, the 2nd, and the 23rd of October,